All right, so the next case we'll look at is the Pappas and Bianca Investments case, which is a unilateral mistake as to identity case. So there was a fraudster involved in the purchase of a car. Okay, and this case is a really good one also for exploring the impact on innocent third-party rights. All right, in terms of the facts here, I mentioned that there was a rogue involved. So in this case, Pappas sold a car to a rogue for $12,500. The rogue had forged their identity and also tampered with a check, which is what they paid for the car with. The day after the rogue took the car from the car yard, they used that car as security for a loan. They originally asked for a loan of $7,000 from this pawnbroker, but the pawnbroker said, no, you can only have $5,500. And in the process of processing that loan, Bianca first did check that the car wasn't lost or stolen before the money was lent. The car was then left as security for the loan. On that same day, so the day after the car had been originally purchased from Pappas, Pappas then tried to bank the check that the rogue had left him. The bank told him later in that day that the check had actually been written for $20 and it had been tampered with to state the $12,500, which was the sale price for the car. And then the day after, the bank then confirmed that the check had been dishonoured. So Pappas, the seller of the car, originally then sought to recover the car from Bianca Investments, who were holding that car as security for that loan. And they argued that the contract between themselves and the rogue was void for the mistake. And the significance being, if the contract was void for mistake, that means title could never have passed validly to Bianca. And in this case, it was ultimately held that an objective reading of the contract supported that the contract had come into existence. So there was agreement of terms and subject matter between Pappas and the rogue, and as such, the contract was not void for mistake. So the plaintiff would have had the right to rescind in equity because there was obviously misrepresentation here. However, the title had validly passed to the innocent third party, Bianca, before the plaintiff had that opportunity to rescind the contract. So in terms of the mistakes that Pappas made, so Pappas and his son, they thought they were dealing with a man named Charrington and that the check tendered was a good check. And not only was the man not Charrington, it was a bad check. On what legal theory did Pappas argue that his contract with Charrington was void? If you have a look around paragraph 25, there's discussion of this. So here, Pappas argued with reference to a subjective approach that the contract was void. However, Chief Justice Doyle emphasised that at paragraph 25 that he believed the objective approach was the correct one, and the quotes there on the slide. So there's an agreement of terms and subject matter, nothing to suggest that the plaintiff was unwilling to deal with the purchaser, whoever the purchaser might be. So here, the identity of the purchaser wasn't crucial. It's not like Pappas and his son only wanted to deal with Charrington for some reason, but no one else. So there was no mistake as to identity. It was really just a mistake as to attributes, as to Charrington's, or whatever his name actually was, creditworthiness. And then, yeah, as mentioned earlier, the reason why Pappas wanted to show the contract void would be because that means that the third party had no rights. Now, in terms of the third question, so are there mistakes in which a mistake as to identity prevents a contract being formed? Yes, there is, but it's quite limited, and it's literally just when the person, the identity of the party is crucial to the contract. So when that mistake is material, so when the mistake is to the identity of the person rather than merely to his attributes, to their attributes, there is a presumption. And the reason being is that there's a presumption that each party intends to deal with the person in front of them, okay, regardless of whether their name is Charrington or not. Okay? But obviously this presumption can be rebutted. So if the party is only intended to deal with, for example, a famous actor, then in that instance, that contract could be found to be void at common law. So in terms of Pappas's mistaken assumption that the check was good, why didn't this mistake make the contract void? As mentioned, it was a mistake only to the attributes of Cherrington as to his creditworthiness. Okay, and there was clearly an intention to contract with the person in front of them. And them being a car sales yard, their intention, is to contract with anyone who has money to purchase. Okay. All right. So the next one, are there any circumstances, in your opinion, in which the rights of two innocent victims of the fraudster, like in this case, both Pappas and Bianca, were innocent? Can that be satisfactorily resolved? Yeah. My answer is no. I don't think so. No, not unless the fraudster is found. Yeah, because obviously here either the contract is void, in which case the innocent third party misses out. So in that instance, Pappas would have lost their 5,000. Their 5,500. Was it 5,500? Yeah, whatever. 5,500, I think it was. They would have lost that money. Or alternatively, Pappas here lost their value of the car. Is there a need for common law of mistake? Yeah, I think so. If the person was literally only wishing to contract with one particular person, although that might be quite rare, for example, if it's a shop who's happy to sell to anyone. But yeah, I think sometimes the identity of the person could be relevant. But, it's up to you whether you think that one is useful or not. And then in question 6, it just goes through the fact, as mentioned, that Pappas lost the whole of the money for the car. Bianca stood to lose 5,500, but in actual fact, they gained 7,000. Okay, assuming that the car was worth more. Would a fairer outcome have been that Pappas be allowed to recover the car if they were willing to pay Bianca 5,500? Well, maybe that's a fairer outcome. It seems quite a silly outcome given that there was no pre-existing contractual relationship between Pappas and Bianca at all, but maybe fairer. It's quite creative, I guess. And in terms of why the law doesn't allow this result, well, rescission is only possible if title hasn't passed, and here title has passed and the title is clear. So, the third party was innocent, therefore they just get lucky, I guess. In terms of the last question there, so might it allow a different result if the basis of the operative mistake was accepted to be an unconscionable assertion of legal rights? To me, this question is really pushing you towards the possibility of unjust enrichment in this scenario, which is something that we'll come back to looking at in semester 2. So unjust enrichment is the general doctrine that where a benefit has been received by the defendant and the benefit is at the expense of the plaintiff, rescission is possible. So the money potentially or the good could go back to the first party, but this is only when it would be unjust in the circumstances to allow the defendant to retain the benefit. And here unjustness refers to the existence of a vitiating factor. So you would need to be able to prove unconscionability here for unjust enrichment to become live as a potential remedy. But don't worry about that one too much. We'll come back to unjust enrichment in semester 2 when we look at damages. Not just damages, remedies. Damages and things like unjust enrichment. Okay. Thanks, guys.